Can the government criminally investigate a politician for criticizing the government itself? Because if the answer is yes, your speech just became evidence. That question is now being tested in reported federal scrutiny involving Minnesota Governor Tim Walz and Minneapolis Mayor Jacob Frey. But the focus is not secret meetings, no hidden orders, no back-channel coordination. And here's the real danger. If speech alone can be treated as obstruction, then criticism becomes conspiracy, and silence becomes self-defense. That doesn't just affect politicians, it affects everyone. Keep watching. By the end of this video, you'll know exactly where the First Amendment draws the line, and why prosecutors almost always lose when they try to erase it. Now the facts. Federal authorities are examining whether Minnesota officials conspired to impede federal immigration enforcement. But the focus is not secret meetings, not hidden orders, not back-channel coordination. It's public statements. And that's where this case stops being about immigration and starts being about whether words alone can trigger criminal liability. According to initial reporting, those statements followed a controversial ICE operation that ended with a civilian fatally shot during the encounter. Tensions were already high. In the aftermath, Governor Walz and Mayor Frey sharply criticized the federal presence. They called the operation dangerous, they questioned its necessity, and they urged public scrutiny of federal agents' actions. However, what they did not do, at least publicly, was order anyone to block agents, interfere with arrests, or refuse lawful cooperation. Still, the Justice Department is reportedly examining whether those statements crossed a criminal line, which raises the core legal question. When does political opposition become criminal obstruction? The government's potential theory is narrow but aggressive. Federal law makes it a crime to conspire to impede federal officers in the performance of their duties. Prosecutors don't need secret orders for this theory to work. They only need speech that predictably changes behavior on the ground. They may argue that repeated, coordinated public statements by top state and city officials created an environment that discouraged cooperation with ICE or encouraged resistance to federal enforcement. In other words, that speech itself became part of the interference. If accepted, that theory collapses a line between dissent and obstruction and runs directly into a constitutional problem. The defense argument begins and almost ends with the First Amendment. Political speech sits at the very top of constitutional protection. Criticizing federal policy is protected. Opposing enforcement strategies is protected. Urging public oversight of governmental actors is protected. Even harsh, angry, or inflammatory rhetoric does not lose protection simply because it makes law enforcement's job harder. And here's the problem for prosecutors. Every element they need is missing. There is no evidence that Governor Walz or Mayor Frey directed anyone to obstruct federal officers, coordinated with others to block enforcement, issued instructions to interfere with arrests, or took concrete steps to sabotage federal operations. That distinction matters because speech does not become criminal unless it is essential to criminal conduct. Now, the cross-examination. This is where cases like this usually collapse. Yes, the First Amendment does not protect speech that is a command, a directive, or part of a criminal agreement. But courts draw a hard line between advocacy and action. Saying this operation is wrong is not the same as saying stop the operation. Criticizing ICE is not the same as obstructing ICE. Shared views do not create a conspiracy. To cross the constitutional line, the government must prove criminal intent, an agreement or coordination, and actual interference with federal duties. So far, public reporting shows only rhetoric, not commands. Opposition, not obstruction. Now let's turn to the law. The Supreme Court has been clear. Speech loses First Amendment protection only when it becomes an integral part of a crime. That means prosecutors must prove more than discomfort, more than political disagreement, and more than sharp criticism. They must demonstrate that speech was used as a tool to carry out unlawful conduct. And there is also a deeper issue here. Charging a sitting governor for political speech raises serious federalism and separation of powers concerns. Courts are deeply wary of precedents that allow the federal government to criminalize state officials by opposing federal policy. Because once speech becomes evidence of a conspiracy, silence becomes the safest political position. And that is exactly what the First Amendment exists to prevent. Now, my ruling. This isn't even a close First Amendment question. Based on what is publicly known right now, this appears to be a constitutional dispute, not a criminal case. Political criticism of federal enforcement, even harsh criticism, is protected speech. Absent evidence of directives, coordination, or real-world interference, the Constitution does not permit criminal charges. Full stop. That does not mean scrutiny is illegitimate. Prosecutors are allowed to ask tough questions, but unless the government can point to conduct, not commentary, this case runs straight into a constitutional wall. In America, criticizing the government is not a crime, even when the government is wearing a badge. Thanks for watching. If you found this breakdown helpful, please like and subscribe. It really does help the channel grow. And always remember, the truth matters, and so does reasonable doubt. See you in the next case.